Hi, everyone. Just going to give everyone a moment to connect. So just a few more joining. Great. Well, thank you, everyone. Appreciate the patience as we got everything set up here. Welcome to today's CLE program, sponsored by the Trademark Committee of the IP section of the Georgia State Bar. And it's titled Domain Name Disputes in the Age of Coronavirus. And I am Jason Rosenberg. I'm a partner at Alston & Bird and the vice chair of the Trademark Committee, joined by the chair, Oma Reggie. And we are very excited about this program. For the first time in history, we've got all three domain name panelists that are barred in the state of Georgia here at one time speaking together for the first time. They are Doug Eisenberg, Larry Nodine, and Brad Slutsky. And as I mentioned, they're all domain name panelists at WIPO, the World Intellectual Property Organization in Geneva. And today, as I said, they're the first time they've ever spoken together. So in just a minute, they'll be talking with us about the general topic of domain name disputes, including under the UDRP, the Uniform Domain Name Dispute Resolution Policy, as well as in court, and with a particular focus on why we're seeing such a spike in cyber squatting matters during this ongoing coronavirus pandemic. And of course, how trademark owners can help themselves and address those issues. So first, housekeeping moment, any questions we're going to save to the end. I think it'll be a little bit easier to handle. So please chat them to me. I'll organize them and present them to the panelists. We've built in time for plenty of questions at the end, so please do that. Regarding CLE, you do not need to email Lane or anyone else at the state bar. It will be taken care of. If you registered with your state bar number, the credit will be given to you in due course. So thank you so much. And finally, a thank you to Caitlin Hawker, who is a first year at Georgia Law and has volunteered to help report on this presentation today for our IP section newsletter. So thanks, Caitlin. Appreciate your help and your interest in the IP section. And now I'm going to turn it over to Uma to give more detailed introductions of our panelists. Thanks.
Wonderful. Thank you, Jason, and welcome again, everybody. We're very excited to host this program. We are in for a treat. So just bear with me. I'm going to do a deeper dive into each of our panelists. So I'll start with Doug Eisenberg. Doug is a former chair of the State Bar of Georgia's Intellectual Property Law section and is the founder of the Giga Law Firm and has focused his practice on online brand protection for 25 years. He maintains one of the world's most active domain name practices, frequently representing trademark owners and occasionally domain name registrants under the UDRP and other domain name dispute policies. And he represented applicants and trademark owners in ICANN's expansion of the domain name system in 2012, which, as you remember, resulted in the addition of more than 1,200 new top-level domains to the system. Doug serves as a dispute panelist for WIPO, the forum, formerly the National Arbitration Forum, the Czech Arbitration Court, the Canadian International Internet Dispute Resolution Center, and the Hong Kong office of the Asian Domain Name Dispute Resolution Center. Larry Nodine, our next panelist, is the managing partner of Ballard Spahr's Atlanta office, a member of the firm's intellectual property litigation group and its former practice leader. Larry has served as lead counsel, including first chair trial counsel in more than 300 IP cases in 23 jurisdictions across the United States. He is a former president of the Georgia Bar's IP section and the immediate past chair of INTA's United States Amicus Subcommittee. Larry has served as a WIPO panelist for UDRP disputes since 2003 and teaches internet law as an adjunct at Emory Law School. And last, but certainly not least, Brad Slusky. He is the general counsel of Red Ventures, a digital advertising company that owns and operates websites such as CNET, Healthline, Bankrate, Lonely Planet, and many others. Prior to joining Red Ventures, Brad was the general counsel of Fleet Core Technologies, chief counsel at Qualcomm Technologies, and was a partner in King and Spalding's intellectual property group for 18 years. Brad has been a WIPO domain name panelist for nearly 20 years and has handled more than 100 domain name disputes for clients. So without further ado, we welcome the panelists.
Great, thanks. So this is Doug Eisenberg. I'll get things started. We have a tremendous amount of content to cover today, and I know all of us are happy to stay beyond the hour if necessary to finish up our content and also to take any questions. So, but I want to jump right in, and really my only introductory comment is that the three of us today, Larry and Brad and I, we all aimed to create a CLE program that's not only important and timely for trademark owners and of course their attorneys, but also informative for those at any level, which means if you don't have any experience in this area of the law, then don't worry, because I'm going to get us started by laying a little bit of groundwork about cyber squatting in general. And if you happen to have one of those advanced degrees in domain name disputes, you'll still get plenty out of this program because we're going to cover a lot of ground and really provide a lot of details. So first, why are we even talking about this topic now? And what do we mean by domain name disputes in the age of coronavirus? And let me just get the slides going here. Hopefully this will work properly. So the short answer to the question is that scammers are everywhere these days, trying to take advantage of consumers and therefore also the brands and trademarks that they rely on, which means that the bad guys are doing things like sending out phishing emails, as you can see here, for fake vaccine appointments. And many of those scams, of course, rely on domain names, as this Washington Post article from September noted, which quoted a report from an organization called Digital Citizens Alliance, which said, quote, "As long as the number of COVID cases continues to grow, scammers and domainers will capitalize on Americans' fear and uncertainty," close quote. And that was before we even had a vaccine. So the abuses really have only been growing online. In fact, one report has found more than 84,000 recent domain name registration that contain the words corona or COVID, let alone other related words such as vaccine or ventilator, or of course, typographical spellings of these words. And granted, many of these domain names do not contain trademarks, but some of them do. And so as a result, they're targeting specific trademark owners and their consumers through what is commonly known as cyber squatting. But there really is no universal definition of cyber squatting, which is a term that was first used in the mid-1990s, as many of you surely know, before many of our clients and many trademark owners recognized the importance of the internet and the potential problems that could be caused by the registration and use of domain names that contain their trademarks. So in the early days of cyber squatting, the problem was identified as a type of trademark infringement and even trademark dilution, since the Federal Trademark Dilution Act had just gone into effect in 1995, which was coincidentally about the same time that cyber squatting arrived. But trademark laws were not entirely well equipped to address the issues created by essentially bad faith registration or use of domain names. So we saw things such as traditional trademark confusion and counterfeiting online, but also new types of online activities arose, such as phishing, spreading malware, deceptive advertising, pornography, blackmail, and other scams that prompted trademark owners to seek control of domain names registered by others. So, of course, humans have always found creative ways to get things they don't have, but using a gun to wrestle a domain name away from a cyber squatter, as one man in Iowa actually tried to get a domain name for himself in 2019, that's not a viable or legal option. And so as a result, or long before that rather, that's where domain name dispute policies arose. And these were created really as an alternative to using traditional trademark laws against cyber squatters. They're contractual policies, and especially the UDRP, or Uniform Domain Name Dispute Resolution Policy, which I'll explain in a moment. They provide uniform rules, as the name says, for domain name disputes worldwide, eliminating jurisdictional issues and offering relief in a much quicker and less expensive manner. And in particular, the UDRP, as you can see here, has proven to be extremely popular. And I'll talk in a moment just about how popular it is for trademark owners, since it was created in 1999 by ICANN, the Internet Corporation for Assigned Names and Numbers, which is the nonprofit entity responsible effectively for the domain name system. Now, as you may or may not know, a typical UDRP case can be filed for about $1,500 and is often resolved in only about 2 months, all of the proceedings taking place online with no need for expensive or time-consuming litigation procedures such as discovery, motions, hearings, or trials. The UDRP applies by contract to the .com top-level domain and most other top-level domains, which enables a trademark owner to obtain a decision ordering the transfer of that domain name, which is an order that registrars are technically required to implement. So we could spend the full hour and many more hours just talking about how the UDRP works. But in the interest of time, the most important thing to know is that the UDRP has a 3-part test. So when filing a complaint, a trademark owner has to prove by a preponderance of evidence that the disputed domain name is identical or confusingly similar to a trademark in which it has rights, that the registrant of the domain name has no rights or legitimate interest in it, and that the domain name was registered and is being used in bad faith. Now, the UDRP policy itself, as well as the literally tens of thousands of decisions over the past 22 years, obviously add a great deal of detail to all the parts of this test. So trademark owners can file UDRP complaints at any of the now 6 ICANN-approved service providers, the largest of which is WIPO, the World Intellectual Property Organization in Geneva. But many of you may also be familiar with the Forum, formerly known as the National Arbitration Forum, which is the only US-based provider in Minneapolis, and it receives the 2nd largest number of complaints under the UDRP. The other providers that you see listed here are based in Prague with multiple offices in Asia, also in Jordan, and most recently in Canada, although it's important to remember that they all administer the exact same UDRP policy. So trademark owners can file complaints with any of them, no matter where they are or where the alleged cyber squatter itself is located. So the UDRP has proven, as I said before, to be extremely popular for trademark owners. And the number of cases filed in recent years, as you can see, has been steadily increasing. This chart that you're looking at right now actually doesn't reflect all UDRP cases. It only shows those at WIPO. And it actually includes some cases under other domain dispute policies, not just the UDRP, but the point is still the same. It's pretty clear. 2020, as you can see, was yet another record-setting year for domain name disputes. And fortunately for trademark owners, the UDRP is serving them quite well. At WIPO, more than 88% of all domain name complaints that have ever been filed have resulted in orders transferring the disputed domain names to the trademark owners or the complainants. In a small number of cases, only about 1.5%, the disputed domain names have been canceled. And in about 10% of cases through the years, have domain name registrants or the alleged cyber squatters defeated a UDRP complaint, which effectively allows them to keep their domain names. So that's a large bit of background. And I guess, the next question to ask is, why are we seeing such a spike in UDRP complaints and other domain name disputes now? So I think there are several reasons. WIPO recently issued a press release on the topic, noting that it handled 50,000 cases through the years. And remember, that's just WIPO's caseload, not all UDRP cases, which are handled by the other providers. So the WIPO press release said that, quote, the COVID-19 pandemic has fueled cyber squatting cases, close quote. And they cited an increase, among other things, in people working from home, which I think means that more potential victims are online more often. And WIPO also referred to an increase in the number of domain name registrations in general, which I think means that there are simply more bad actors out there, perhaps trying to seek financial gain during hard times by engaging in cyber squatting. So in any event, I want to turn now to discuss a few real UDRP decisions that relate to the pandemic. The very first coronavirus specific UDRP case was for the domain name, as you can see here, coronavirusgoogle.com. Google filed its UDRP complaint at the forum for this case in March 2020, right around the time that many states and cities around the United States were starting their lockdowns. Now, one thing to keep in mind is that UDRP complaints and responses, when there are responses and other documents, are not publicly available. So really what the public can learn from UDRP cases is what are simply in the decisions, which are published online by the providers. So the decision in this case for coronavirusgoogle.com was pretty short and came just a month after the case was filed. And it really doesn't say much about how the domain name was being used, other than it says, quote, respondent uses the domain name to pass itself off as complainant online in order to redirect internet users seeking complainant's products or services to a website that has no affiliation with complainant, close quote. So in this case, the registrant of the domain name did not submit a response, which, by the way, is not uncommon in UDRP cases, although it's also important to keep in mind that there's no such thing as a default judgment. And the registrant of the domain name actually offered, after the UDRP complaint was filed, to transfer the domain name to Google. So as sometimes happens in this situation, the UDRP panelists did not issue a substantive decision on the merits of the case, but simply agreed to accept the registrant's offer to settle and ordered a transfer of the domain name. The next UDRP case I want to focus on did not include the words coronavirus or COVID or anything similar, but it obviously related to the pandemic because it was for the domain name purellonline.com and was filed by the owner of the Purell trademark Gojo, which had found a website with the domain name that was selling counterfeit versions of the Purell brand of hand sanitizers that we all recognize, and said that the domain name was also being used in connection with a phishing scheme. So in this case, the UDRP panel easily found bad faith on several fronts. I should note that usually phishing by itself is evidence of bad faith under the UDRP. But also in this case, the panelists noted that what is sometimes referred to as opportunistic bad faith, which arises when a domain name is registered and used in connection with a specific event, which here obviously was the coronavirus. So the third and last case I just wanted to mention before I hand the controls over is one that was filed at WIPO by a British governmental entity. It's formally known as Her Majesty's Revenue and Customs, which is often shortened to HMRC. So as you can see, the disputed domain name in this case was hmrc-refund-covid19.com. It obviously contained the HMRC trademark, and as often happens in UDRP cases, it was being used in connection with a site that was distributing malware. So here, just like in the Purell case, the panelists under the UDRP had no trouble finding bad faith and wrote that the cyber squatter was, quote, cynically targeting internet users who may already feel vulnerable and be desperately searching for some good news amidst all the suffering and disruption, close quote. So I will now let Brad take the reins, followed by Larry, and then I'll be back with some comments in a few minutes about the future of domain name disputes, and then hopefully, as we said, have plenty of time for questions.
Sorry about that muted Zoom problem. My fault. Thanks, Doug. I want to talk about 3 domain name cases. And although Doug shared with you the very first coronavirus related domain name case, the first coronavirus domain name case that I'm going to talk about is a 2008 case before we had COVID-19. And the reason I wanted to talk about it is that I was the panelist in the case, and I thought it was relevant to the kinds of scams that we see today in connection with coronavirus. This was a case brought by Synovia Ventus involving the domain name buyambien.com. The website was being used to sell products that were competitive to Ambien, which would be a classic form of bad faith, but also was being used to sell a prescription drug, Ambien, without needing a prescription. And there are bad faith factors that are listed in the UDRP. Not requiring a prescription is not one of them, but there are many cases that hold that those factors are non-exclusive. And so this is a case where I noted that selling a prescription drug without a prescription is evidence of bad faith, obviously potentially useful in connection with domain name scams. Fast forward to 2020 now, another case involving Sanofi, and the domain name in this case is plaquenil.org. If you don't recognize that, Plaquenil is a brand name for the drug hydroxychloroquine. You may recall from this past summer, there was a lot in the press about hydroxychloroquine with President Trump indicating that it could cure coronavirus. Dr. Fauci saying that the studies show that it doesn't cure coronavirus. President Trump retweeting that Dr. Fauci was misleading the American public. President Trump saying, well, Dr. Stella Emanuel says that it can cure coronavirus. Press then finds out that Dr. Stella Emanuel also says that doctors are using alien DNA to make medicine. Point being, it was in the press quite a lot. And so the domain name in this case was registered right around the time that all of this press was hitting. And the panel found that the registrant would have been aware of the trademark and was using the pay-per-click links on the site for commercial purposes and in bad faith. Last case really briefly involves KN95 masks. I thought this case was particularly interesting. The background makes this hard, but I'm holding up a bag of POW Ecom KN95 masks because they are the kind that I use. And the respondent in this case was using the domain name to sell competing brands of masks, and that's classic bad faith. And so the domain registrant lost that case as well. So with that, I'll turn it over to Larry.
Thank you. You see my screen, everyone? Oh, somebody give me up. So I'm Larry Nodine. Quick thank you to Naomi Busso-Cotard, who a student at Emory who helped me with this, who did a fine job. We're going to shift a little bit and sort of make it clear that it's not only the UDRP that is applicable to these disputes. The DOJ and many state attorneys general are also involved. But here's an example of one that is, we're going to get into one in just a second. The DOJ has seen just a tremendous lot of activity in this area, 3,600 domain name complaints. In addition, the FTC has received about 193,000 reports of COVID fraud. One recent, I think there are a lot of studies going around. One recent study that we saw was 40,000 domain names registered. 22,000 of those at least contain malware. One of the cases we're going to talk about is this one. This is a favorite of mine. This was a DOJ case filed in Texas on, you'll notice the date there, of March 21, 2020. By the way, if you also see my advanced slides, that's okay. That's Fauci there. This was,
Larry,
yes.
this is Alma. I'm not sure we're seeing your slides. I don't know if everybody is seeing the slides.
You
It's
see
still
it.
on the first page.
It's just on the first page.
I believe it may be that presenter view checkbox that Lane had referred to earlier, may be the fix. If Lane can step in and help out, that'd be great.
Larry, can you share your screen again, please?
Mm-hmm.
Okay, you should click Use Presenter View. It's a checkbox. And then start your slideshow, and let's see what that does.
How we doing?
Here we go. Perfect. Thanks, Larry.
Sorry, everyone. So this DOJ case in Texas, notice the date of this filing up here, March 21, 2020, very early into the work from home time. And that's Fauci that's being displayed on this website. I like this one in particular because of the representation. You just need to add water and the drugs and the vaccines are ready to be administered, offering to sell you. Well, the representation is that the World Health Organization is giving away free vaccine kits. You just have to pay for the shipping. And of course, following the links would get you in the trouble that you would expect. DOJ in this case relied on wire fraud, but it's interesting that there's also a civil remedy for the criminal offense of wire fraud. And in this case, sought an injunction that would also be effective against Namecheap, ordering them to stop making the website available. The general point being that the fraud doesn't always involve trademarks. And in this COVID period, we can get help from the Department of Justice in some cases. And of course, you can report your problem to the FBI. I've dropped into the chat copies of the slideshow that we're talking about, but also the TRO motion that was filed in this case that you may find useful as a go-by. And then in addition, a case we're not going to talk about very much, but a Microsoft case filed again early in the pandemic period in which they relied on the Consumer Fraud and Abuse Act and trespass to chattel conversion with respect to the related malware that often goes with this kind of abuse. You may find that useful. We've talked a lot about the UDRP, and we need to be sort of mindful of its limitations. The one thing about the UDRP, to be clear, is that, well, overview, first of all, as Doug noted, the complainants win about 90% of the time, roughly, and in single panel rulings. In 3-panel rulings, it's about 50-50. But the point, as we talk about limitations, is to be somewhat circumspect about it. Any proceeding that results in a 90% success rate can't really be called that limited. But nonetheless, the complainant only gets one shot. The one thing to remember is, of course, the flip side of no discovery and no expensive litigation at cost is that you don't have a lot of the tools of regular litigation. You write a complaint, and it's important to think of it pretty much like a summary judgment brief rather than notice pleadings. Consequently, it's not really suitable for vulnerable trademarks. If you've got a borderline mark that's simply generic and you might have to be aggressively advocating on the plaintiff's side, you may not want to take the chance or you may want to think twice about taking the chance with the UDRP. And in general, it's just not appropriate for what we call ordinary disputes. It's for cyber squatting. So if you have, for example, a dispute between two trademark owners and the defendant really is doing business and there's a legitimate trademark dispute going on, it's wrong to use the UDRP to try to run around litigation proceedings. We're going to focus on these last two limitations: de novo review by federal courts and reverse domain name hijacking. It's not really correct to talk about review, because the way it works is that the UDRP, after a transfer order is entered after a decision, there's a 10-day wait period. And if either party files a lawsuit and a regular lawsuit, shall we say, in a national court, then the transfer order is just suspended. Now, you can also, the question is, how do you get into federal court? Well, the ACPA, the Anti-Cyber Squatting Consumer Protection Act, which we're going to talk about more in a second, creates a jurisdictional base for resolving ownership disputes with respect to domain names. So there is a tool for getting into court. When you're in federal court, there is no deference to the UDRP decision. It's not, in fact, considered a true arbitration proceeding under the Federal Arbitration Act, which would trigger deference. There is no deference, and the decision is not precedential. So there's this, you might consider it a limitation of being reviewed. I want to note that I don't really think of it as a problem. It's important to recognize that the reason the UDRP has been successfully invoked worldwide, not just the United States, but in every country in the world, is because it doesn't challenge national sovereignty. Basically, the national courts don't worry about the UDRP in the sense of being a challenge to sovereignty, because they don't have to defer to it. And regardless, even though technically their appeal is available, it rarely happens. I can find only 200 reported cases, even mentioning the UDRP, even though, as Doug was telling you, over 50,000 decisions by WIPO alone. There's also the limitation of reverse domain name hijacking. This is when a trademark owner tries to, can't get a domain name otherwise and tries to use the UDRP or any other proceeding to try to get a domain name. A classic example would be where the domain name was registered well in advance of the trademark owner acquiring rights, which would render frivolous a UDRP complaint. There's also so you can, if that happens, a UDRP panelist is required, really, shall declare reverse domain name hijacking. But there's nothing that happens. There's no penalty under the UDRP. It's just a statement. It's a scolding, if you will. However, under the ACPA, there's a comparable proceeding or a comparable remedy for reverse domain name hijacking. If you can show knowing and material misrepresentations, then you get standard typical damages, costs, and attorney's fees. So of course, the ACPA court can undo the transfer. So there is a remedy in federal court. When is the UDRP? What is not enough? Well, that's when we've been talking about under the ACPA. You can go into regular federal court to try to fix a domain name problem. And by and large, the elements of the cause of action for the ACPA claim are roughly the same as under the UDRP, but there's one important difference, and that is that under the ACPA, you only have to prove bad faith registration or use, or bad faith use. That's important because under the UDRP, if someone registers in good faith but then transitions to bad faith, the transfer should be denied. That you're missing the element of bad faith registration and use, which exists under the UDRP. But under the ACPA, earlier good faith registration, when it switches to bad faith, can give rise to a claim. And that's probably the most important substantive reason to consider an ACPA claim instead of UDRP claim. How do you get federal court jurisdiction? Of course, you can get personal jurisdiction. That's tricky in many cases in domain name disputes because a lot of times you don't know who, you don't have good information to satisfy minimum contacts requirements with respect to who the domain name owner is. And therefore, the ACPA provides for in rem jurisdiction, where the domain name itself is the property, is the race, and it exists. The situs of the property is where the domain name registrar or registry is. Often that's the Eastern District of Virginia, where VeriSign is. So the domain name is set to reside where the registry is, and consequently, you can file interim cases in, for example, the Eastern District of Virginia. Of course, you're limited to transfer. You can't get money damages in that case, but it still provides. It's important to recognize that effectively gives you worldwide jurisdiction over all .coms, because at least in rem jurisdiction, that's pretty incredible. The remedies, of course, are transfer, cancellation. You can also get under the ACPA standard Lanham Act remedies, but you can also get statutory damages or elect to get statutory damages for the domain name part of the claim, with statutory damages as high as $100,000. You can, in addition, get both. If you think of both the content of the page and the domain name itself, with respect to the content of the page, you could get Lanham Act damages as well, in addition to the statutory damages available. When to do, I guess it's somewhat self-evident. You'd use the ACPA if you want money, if you have a problem showing bad faith registration, even if you're looking at bad faith use. And of course, you get discovery, preclusion, and precedent. I noted earlier that the UDRP decisions are not precedential. And it's in general better for the more complex cases involving rival claimants. Thanks. Back.
Okay, so as the in-house lawyer on the panel, I thought I would talk about what in-house attorneys look for in connection with UDRP proceedings. When you're in-house, your company often wants things done quickly, inexpensively, and effectively. So a UDRP case can typically take about 2 months, as Doug mentioned, versus a year plus for trademark litigation. Cost is all in around $10,000. You have a $1,500 filing fee for a one panelist case and around $8,500 in legal fees, versus a trademark case can easily cost $100,000 or more. A very complicated one could exceed $1 million. And as you've heard from both of the other panelists, likelihood of prevailing in a at least WIPO and NAF case is roughly 90%. So, cheaper, faster, and 90% win rate, that's a win when you're in-house. As Larry mentioned, monetary damages are not an option. Transfer and cancellation are the only remedies available in a UDRP proceeding. So if you want money, you need to go to court under the ACPA or other statutes. A comment I would make as an in-house counsel, experience really counts in these things. As Doug indicated, a lot of times there is no response filed, but sometimes there is. And whether or not to accept a reply in response to the defendant's response is at the discretion of the arbitrators, and frequently the arbitrators deny the right for any other pleading. So inexperienced counsel will anticipate what might appear in a response and go ahead and make arguments with respect to that, because that might be your last shot at saying anything that the panelist is going to use in making a decision. Also, a UDRP case is not federal or state litigation. State and federal procedural rules do not apply. That gives you an opportunity to be somewhat creative that you might not be able to do in federal court. And I thought a good illustration of that was a case that we brought when I was at Fleet Corps, where an individual named Andrew Left, who is a notorious serial short seller, put negative information about FleetCor on a website, then published articles about that, went on TV shows and did press interviews, all in an effort to drive down the price of the stock to make his short position more valuable. And then he would buy back the stock after the price went down, buying low and selling high, but in the reverse of the usual order. If you saw the movie Trading Places with Eddie Murphy and Dan Aykroyd, that's how they made their money at the end of the movie. The problem here, though, was that Mr. Left used a privacy service to keep his name out of the registration. And so all we knew was that registration private / domains by proxy was the registrant. And we couldn't in good faith file a complaint against Mr. Left. So if you're in federal court, you get the advice that we got from our outside counsel in the case, which was do some more investigation, see if you can figure out something that indicates that it's definitely him, and only then file. But here's where experience can come in these cases. So instead of doing that, we sued the anonymization service and said that whoever is behind this, we didn't name Mr. Left, is a short seller, and they're engaging in a scheme of trying to make money on our stock by publishing false information. And what happens in those cases is that the dispute resolution provider takes the complaint, sends it to the anonymization service, and says, you've just been sued. You need to name who is the actual registrant of the domain name. Then they send the complaint back to the complainant and say, your complaint is rejected. You sued the wrong party. The actual registrant is so-and-so. If you want to proceed, amend your complaint and name the correct person. So that was our strategy. We figured if it came back as we suspected it would, and Andrew Left was the registrant, we would change the name at the top and pursue the case. If it came back and it was a former customer with a gripe or a Boy Scout or Girl Scout or what have you, we would probably dismiss that case. Last thing I'll say from an in-house counsel perspective is that losing one case can make it a bad day for you. If you have a trademark that a lot of people are using to register domain names, and you have to bring these cases periodically, once you lose, that lost case is going to be cited against you forevermore. And so again, experience helps to try to be on the right side of that 90% and win these cases as often as possible. Word about free speech. I just got through saying that complainants win about 90% of the time. You heard the other panelists say that as well. That is not true in free speech cases. So, if you serve a client for any period of time, you are likely to get a question along the lines of, somebody on the internet is saying something mean about us, can we sue them? And typically for me, the answer to that is something along the lines of, yes, of course, you can sue anybody, but the real question is whether you should. And there are lots of memes and cartoons on the internet that kind of illustrate this process. There's this XKCD comic that I like that you can see in the bottom middle. No shocker that somebody would be wrong or have a very strong but incorrect opinion on social media. And the question you should really ask yourself is that a fight? Are you going to win that fight by kicking it off, or are you going to give the other side a win just by starting a dispute? Because there's likely to be more press about the matter once you bring it. And as I said, these are not the cases where the complainant wins 90% of the time. These are much harder, and you would want to make sure that you win it. So talk about a few free speech cases. This first one, Nix Solutions versus WhoIsGuard / Son Ferguson. Again, that was another case where there was an anonymous registrant. There's a screenshot of that on the right side of the slide. And I took that just before this seminar, which since that's a 2014 case and the nixsolutionssucks.com domain is still active with that content, you can infer that the complainant lost that case. That website, the owner of it says things on it like, These rogue companies, their owners and their employees have scammed a former client out of millions of dollars. The site also contains a link to a 50+ page complaint against Nix Solutions. And probably very annoyingly to the Nix Solutions people, there's also a whole list of pictures of employees and other people associated with the company and all the contact information that the person could find about them. And above that list, the heading says list of scammers and thieves. So no great surprise, that was considered to be First Amendment speech and not bad faith. And so the registrant won in that case. I'm not going to talk about all of the cases that are listed in the materials. You'll get a copy of them and you can study them. But an interesting one on this next page that I thought I'd talk about is the lower one involving the University of Missouri versus Pamela Holly. And there's an interesting / comedic pro tip in this case. So in this case, Pamela Holly brought her daughter to MU Healthcare for treatment. And after she left, she got a bill for what she said were services that were not rendered to her daughter. And she was unable to resolve that complaint with the university, and got to the point where she was so angry about it, she decided she would register a domain name and take her case to the public. When she went to register a domain name, she discovered that MU Healthcare had not registered muhealthcare.com. So she registered it, and she put her complaint information on the site. And then eventually over time, she moved away and she decided she didn't really have much interest in maintaining it anymore. So she forwarded the domain to a website that had some more comedic and innocuous content on it. Over time, however, that website evolved into a white supremacist website. And when Ms. Holly found that out, she stopped the forwarding. And that resulted in the website looking like what you see on the bottom right here, which is a parked page with pay-per-click links. But roughly around the same time, the university also discovered the white supremacist website, and they'd had enough at that point, and they brought a UDRP proceeding. And in that case, there's some interesting holdings. One, they held that the domain name was identical to the MU Healthcare's trademark. Two, they held that the respondent did not have rights or legitimate interests, even though it was a gripe site, for the reason that that should be measured at the time the proceeding was filed. And at the time the proceeding was filed, the site was being used for pay-per-click links. But to Larry's point earlier about registration and use in bad faith, the panel indicated that back at the time that the domain name was registered, it was registered for a legitimate gripe site and therefore found in favor of the respondent. Now, the pro tip here, especially if anybody who's watching this is affiliated with the university, Missouri University happened to own a university newspaper. They also happened to have a law school. And at the time the domain name was registered, the university newspaper ran an article about the registration of the domain and interviewed one of the professors in the law school who said, yeah, this is a gripe site and it's probably protected by the First Amendment. There's nothing we can do about it. So pro tip there, if you're associated with the university, probably not a good idea to have the newspaper that you own in the law firm or the law school that you own publishing information that's contrary to positions that you're going to take. Now, the complainants don't always lose these. I mentioned the case that we brought when I was at Fleet Corps. We were able to convince the panel in that case that although there was gripe information on the site, that it was really just a commercial scheme to make money on a short stock position. And of course, it didn't help Mr. Leff that he went on Bloomberg News and basically said that. And so we prevailed in that case. Also, there's an early and interesting case involving Walmart with a defendant named Richard McLeod. In a brief and not so funny reference, I had to go look up whether he was related to Connor McLeod, and I'll leave it at that if you recognize that name. If not, you might want to Google it because you certainly wouldn't want to sue anybody in that family. Anyway, Richard McLeod registered WalmartSucks.com. And he registered it in the name of Richard McLeod doing business as for sale. And then he offered the domain for sale to Walmart. So the panelist in that case was very concerned about the offering of the domain for sale. And that's clearly bad faith. The registrant said, well, I had a change of heart and I want to use it for free speech now. And the panelist was not buying that. But the panelists did note that the difficult question in that case is whether Walmart Sucks is identical or confusingly similar to the Walmart trademark. Because why would a trademark owner want to register a domain name that basically says that they or their trademark sucks? The panelists found that it was confusingly similar, and there have been some UDRP cases that hold that. There are a lot of federal court cases that say otherwise. And so that's probably not consistent with US trademark law. In fact, there's another UDRP case from the same year, 2000, but a little bit later, where another panelist found that Walmart Canada Sucks was not confusingly similar and found in favor of the respondent. Last thing I'll say on this, and just to bring it full circle, now there's an entire GTLD devoted to telling the world what sucks. And to answer the question of, who would want to register this and indicate that they or their trademark sucks, you can see that Apple has registered apple.sucks. Of course, trademark owners do that to preempt people who may have negative commentary. But the very fact that they need to do that is an indication of the fact that these domains are not reserved just for the trademark owner. So with that, I'll turn it back to Doug.
Great. Thanks, Brad. We obviously have a huge amount of content that we've covered in a short period of time already, and we're running short on time, but I want to kind of address a number of other issues. We've talked so far kind of about what the current state of cyber squatting is and how we got here. But I want to take the remaining few minutes before we have questions and answers to sort of talk about where we go from here. So bear with me for just a moment here to pull up the latest slide. And I really think what I want to just say is that the first and most important thing really to make clear, if it's not already, is that registering and using and buying and selling domain names is a big business, not just for trademark owners, of course, and for other legitimate individuals and companies, but for cyber squatters. So we now actually have more than 370 million domain name registrations out there, and growing at about 3% per year. And of those, about 40% are .com domain names, which account for the overwhelming majority of all domain name disputes, including under the UDRP. But in recent years, as we sort of alluded to earlier, we've had the arrival of what are called new global or generic top-level domains, new GTLDs. And these, the arrival of these really means that cyber squatters have even more opportunities to target trademark owners. So some of the new GTLDs are especially attractive right now and fit with the theme of our program, such as .health, but a number of others with sort of general applicability are starting to appear in UDRP decisions, such as .online, .xyz, .top, .store, and .shop, just to name a few. It's also important to know that there are more than 200 country code or CCTLDs, which granted, these are typically more popular in other parts of the world than in the United States. Every country has its own two-letter country code, such as .uk for the United Kingdom, .ca for Canada, .au for Australia, and so on. About 40 of the CCTLDs have adopted the UDRP, and many of the others have enacted their own domain name dispute policies, some of which are based on the UDRP. And I expect as more countries do adopt the UDRP, which has been happening in recent years, trademark owners will find it even more attractive to pursue cyber squatters in other regions of the world. And speaking of other domain dispute policies, I also think it's worth a quick mention that there is a competing policy to the UDRP. It doesn't get a whole lot of coverage, and that's probably, among other reasons, because it does not apply to .com or .net. which are the most frequently disputed top-level domains. But that's the URS, or the Uniform Rapid Suspension System. This was created really in connection with the rollout of the new GTLDs. It was designed to be a quicker and cheaper alternative to the UDRP, but it never really caught on. And in fact, it's actually been declining in use significantly, in part because it only applies or provides for the temporary suspension of a domain name rather than a transfer, which means it's not a permanent fix to the problem. And also, I think it's worth briefly mentioning, although it will surely be a lengthy process, there's a lot of talk, if not actual action, around what's often referred to as UDRP reform. In other words, whether the UDRP is working well and whether it should be amended or updated in any way. The truth is, it's a very political issue because any change ultimately needs to be approved by ICANN, which created the UDRP in the first place. And as you can imagine, trademark owners and domain name registrants have differing opinions on this topic. But some of the ideas being tossed around relate to some of the topics that Larry mentioned earlier, some of substance, such as whether the requirement for registration and use in bad faith should be changed to registration or use in bad faith. And some of the others, possible reforms relate to procedure, such as whether there should be a built-in appeals process to the UDRP. And so I guess just in closing, before the questions, what I would say is I always tell my clients when it comes to online scams, nothing surprises me anymore, and that's not for a long time. You know, none of us probably would have thought a little more than a year ago that, you know, domain names with the words coronavirus or COVID would be popular for cyber squatters, you know, or that domain names would be used to advertise fake vaccines for a pandemic. But that's exactly where we are, which means that while I'm somewhat encouraged these days by the progress we're making against COVID, I have absolutely no expectation that cyber squatters will disappear anytime soon. So with that, I think Jason or Uma have been collecting questions, if there are any, and we're happy to stick around, even though we're right at an hour now.
Yes, gentlemen, thanks so much. I have been collecting questions, got several good ones here, and to everyone that's still on, thank you for joining. The panelists have agreed to hang out and answer questions for a while longer. So if you've got additional questions, feel free to send them in the chat. I'll look at them. But let's start with some that have been posed. What is your view? And by the way, these were not addressed to anyone individual. Let you guys decide who's going to answer. What is your view of the interaction between U.S. trademark law and the bad faith or rights or legitimate interests prong of the UDRP?
Maybe I'll jump in on that first, and then others can weigh in. So UDRP is not the same thing as U.S. trademark law or any country's trademark law. It's meant to be an expedited procedure for clear cases of cyber squatting. Nevertheless, I typically turn to trademark law when I'm deciding a case and there's a question about whether the respondent has rights or legitimate interests, because that requires a bona fide use of the domain, and bona fide means legal, and legal, if the two parties are in the United States, to me means it complies with US trademark law. So often turn to it there. And also just there are periodically issues that are decided in cases that seem to involve questions that are trademark-like. And I often look at US trademark law if they're US parties, just for advice on what's the answer there, and then think about should that be the same answer in UDRP proceedings.
I think it's a great answer. Unless Larry has something else to add, I would say in the interest of time, move on to other questions. I don't have much to add.
Well, let me just take a few seconds, which is, the question was, what's the relationship to federal law? The constructive knowledge that you get out of the Lanham Act doesn't apply in a UDRP proceeding. And so you generally have to have some basis for inferring knowledge of the plaintiff's rights or the complainant's rights. I'd say that's one of the critical differences in evaluating bad faith under the UDRP, fact-based rather than presumption-based.
And of course, there is no First Amendment in a uniform policy. So especially when the parties or one of the parties may not be in the United States, to talk about, the First Amendment is perhaps irrelevant.
Other questions?
Yeah, so and this is a question I've certainly had clients ask that came from the group, and that is we always hear all the time this issue of whack-a-mole, right? So the UDRP is fast and it's relatively inexpensive, but there's no monetary recovery. How typical is the problem of someone, you might win the UDRP and this bad guy cyber squatter re-registers a new domain with maybe only a slight tweak? And is that a problem you're actually seeing? And if so, what do we do about it?
I would say it's definitely a problem because it is so inexpensive to register and maintain a domain name. So yes, there is certainly a whack-a-mole problem. The good news, if there is any, is that there are also lots of trademarks on which domain name registrants can cyber squat. And so, in my experience, there is a bit of a deterrent effect, so that the more active trademark owners are in pursuing domain name disputes, may prompt cyber squatters to go pick on somebody else. I don't know that that's a perfect solution, but I think that's a bit practical.
Couple of thoughts on that. So I used to do a bunch of when I was in private practice, I did a bunch of domain name work for the Coca-Cola company. And I always cite an example of one of the disputes that we had as an example of why you can neither anticipate all the domains someone is going to register or, whack all the moles. Somebody one time registered Coca-Cola-monkey-jesus.com. And I looked at that and I thought, yeah, we didn't anticipate that one. So, there are definitely the serial registrants out there. I'd say two things about it. One, in hundreds of cases, I haven't come across a lot of people who felt so strongly that they were going to continuously register domains even after they got shot down. But it does happen once in a while. And what I would say in those cases is you need to consider a federal lawsuit against them, potentially get damages and up the stakes for them, make it not worth their while to continue.
Or get an injunction.
Yes, although they could violate that too.
Thanks. What are the differences among the UDRP service providers, and how should someone considering filing a UDRP decide which one to use?
I'll go ahead and jump in there. First of all, as I said in my part of the presentation, they are all six of the providers administer the exact same UDRP policy, and they have to apply the exact same UDRP rules. But each of the providers has their own set of supplemental rules, which cannot differ from the primary rules, but relate to topics such as word count or page count, and other sort of procedural issues, not really substantive. So there are some differences among the providers on some of those procedures. I guess I would just say one misconception that I hear a lot is that because a trademark owner is located in the United States, you need to file your UDRP complaint with the forum because the forum is in the United States, or if your client is in Europe, you need to file with WIPO because WIPO is in Europe, and that's just not true. Anybody anywhere can file with any of the UDRP providers, no matter where the trademark owner is located and where the domain name registrant is located. Now, from a practical point of view, WIPO and the forum account for, I'm not sure exactly, but I would say probably about 90% of all UDRP cases. Look at the different research tools that they offer, the resources that they offer. WIPO publishes effectively an FAQ. It's called the WIPO Overview. There's a slight difference. I mean, I serve as a panelist for multiple providers, but you can look at the roster of the panelists. Not that you necessarily get to choose your panelist, although there's some option for that in a 3-member panel. So I don't know that that's an answer to the question, but those are some differences and considerations.
Thanks. Another question we've gotten, and it's one that I've dealt with as well. So nowadays it seems that almost all of these registrants are privacy protected, whereas before you might actually know who it was and you could group several together. So when now is it appropriate to include multiple domain names in a UDRP complaint? It's obviously more efficient, likely less expensive, but not always obvious when you're first looking at the domains whether there's actually a connection between the registrants.
Go for it, Doug.
Okay, I don't want to talk. I don't want to take all the time. I'll be brief. I think the question is about consolidation. So yes, you can include multiple domain names in a UDRP complaint so long as they're all held by effectively the same domain name holder. I think the question seems to be getting at the issue of what about when the information that you have on who the domain name holder is not clear or perhaps even differs, but you think that they're all related or aliases for one particular person or entity, which often happens. So this also kind of relates to a bit of a difference of how some of the providers handle this issue. And effectively, you need to make an appropriate argument as to why and how differently named domain name registrants are aliases for the same, or why it would be appropriate to include them all in a single complaint. Just by way of example, I recently filed a UDRP complaint. There were 2 different domain names at issue. It was very clear that they were controlled by the same person, but the domain name registrants were listed in the WHOIS records by different names. We included both of them in the complaint, made arguments based on information we had as to why we thought they were related. And lo and behold, after we filed, one of the registrants responds by email to WIPO and to me as complainants counsel and says, we are related, the 2 different registrants. So sometimes you get lucky and they'll state the obvious.
Thanks. When do you advise a client to use a 3-member panel instead of just 1?
I'll jump in on that. So typically, if a case is more iffy, or if there's an aspect of the law where there are some panelists who that's their issue and they rule contrary to common jurisprudence, then I'll go for a 3-member panel because it lowers the likelihood that I draw one person with an odd view. And if that person is on a 3-member panel, hopefully they get outvoted by the other 2. So a good example of that would be cases where somebody is using a trademark to sell a legitimate product. Maybe they don't have permission to do so. There are some panelists who tend to rule that that's okay, even without permission. I think the majority view is that it's not. And so to further increase the odds of prevailing and not get unlucky with the panelists, I would recommend a 3-member panel in a case like that.
Well, statistically, 3-member panels, the win rate for plaintiff is about 50% with 3-member panels. And so my general advice is that if I'm on the complainant side, I wouldn't recommend it. I mean, if you're just going with what did the dice tell you?
Yeah, I mean, just to be clear, either a complainant or a respondent can elect a 3-member panel. I'll avoid the technicalities on that, but it is possible that you file a complaint and only select a 1-member panel, and the respondent has the opportunity to expand it to 3. I completely agree with what Brad said, but I think sometimes it's important to keep in mind if you have significant concerns, if you're exploring an area that's kind of unsettled, then maybe you don't want to be using the UDRP in the first place.
Thanks. Speaking of, maybe getting some panelists with differing thoughts on and views, are any traditional trademark defenses, equitable defenses, for instance, available in UDRP? I don't believe they're in the policy, but are panelists permitted to apply them? And if so, is that something that happens from time to time?
Let me just take a first shot. It's permitted, but one of the things that's interesting is that a sort of latches and delay defense doesn't work as well in the UDRP as it might in court. There are plenty of cases where many years have gone by in which the complainant still prevails.
Anyone else? A question, another one that came in that is one that clients have asked me, especially with regards to the new GTLDs. So you might have a situation where it's clear that your trademark is, that there's a cyber squatter, your trademark is being used in bad faith, no legitimate interest into it, it's confusingly similar. Why do we care? Okay, what is the likelihood that someone is going to stumble across that GTLD? So when it seemed to make, for many clients, a lot of sense, we're talking about .com and .net. Do you go through the same analysis when you're talking about one of now thousands of additional GTLDs?
It's a great question, because it is, and it relates back to the whack-a-mole issue. Ultimately it's a matter of prioritizing. And I think you can prioritize based on the domain name, which may include the top level domain. You can also prioritize obviously based on how it's actually being used. Interestingly, I've seen in recent years probably an increase in either phishing or other types of email scams. Some listening in may be familiar with those that have actually targeted law firms, for fraudulent requests to make wire transfers and so forth. And so sometimes, it's not just is somebody going to mistakenly visit this website and type in this domain name and URL, but if they receive an email with a particular domain name in it, might they overlook it? I mean, I wrote about this recently. .cam, C-A-M, is one of the new top-level domains. It was originally intended, to relate to the camera, photo and film industry, but it is an open GTLD. Anybody can register within it. The fact that it is so similar to .com, I think, makes it, a top-level domain that is ripe for cyber squatting. So, that may be, more important to somebody, than .pizza, unless that happens to be your industry. So.
All right. What would you say was your most interesting UDRP case?
Brad, was it the was yours the Coke case you referred to a minute ago?
I mean, the Coke case is obviously interesting. It's provided a lesson for life. I also thought the FleetCor case was interesting that I talked about, just because we were able to solve the thorny problem of who is the registrant. And also that is the only case that I've been able to find. It was the only one at the time, and I searched last night, couldn't find any either. The only case where basically using a domain name to further a short selling scheme was held to be bad faith. So that one's pretty interesting. I don't know if you guys have had any cases involving celebrities or other things.
Well, I really like my decisions when I'm wearing that hat to speak for themselves. So I don't really want to talk about the decisions, but I'll mention, I think it was in 2007, I had a complaint filed by Donald Trump for the domain name trumpfurniture.com, which resulted in a denial. The domain name was not transferred. And this is not at all a celebrity case, but is maybe one of the more interesting. And this was, I was served on a 3-member panel for a case involving the domain name. I think it was Oogle.com. So that's sort of like Google without the first letter G. And it was, again, you can read the decision, but ultimately the 3-member panel also declined to order a transfer of that domain name. It raises issues about sort of the problems with evidence in UDRP proceedings.
I would just maybe not talk about a particular case, but really I have to say that I've always been fascinated with how profound the UDRP is. I mean, in the history of jurisprudence, this is a system that applies in every country in the United States. It's a very elegant solution to a tremendous problem. If you go back to 1998 and you think of how crazy it was with as cyber, like look at the Panavision case. Now everyone was scrambling for a solution to this this huge problem, both quantitatively and qualitatively. Now we have a proceeding that applies worldwide that has had thousands of decisions. I mean, probably close to 100,000 decisions. Seems to be working pretty well, and the elegance of it is really quite interesting to me. I think that the notion of giving a remedy, but not challenging the sovereignty of the national courts, finding a way to thread that needle, is incredible. And I think that the people at WIPO in particular, I think, were instrumental in drafting the UDRP in the beginning. And if you just look at, I alluded to the statistic that there are only 200 reported decisions that even mention the UDRP in the United States, even though there's a review right. So that there is essentially kind of a deference by conduct to the UDRP worldwide. So I think it's really cool, and I think we as lawyers, I think it's significant just to sort of think of how innovative a proceeding it is, and I think it's really cool.
Great. Still a couple questions coming in. One from the group is, does the panel have any thoughts on the significant increase in domains registered for employment scams, and whether those should be tackled with a UDRP complaint or some other mechanism?
I'll say I've seen a lot of those recently, and if the question relates to what I've seen, it's effectively some scammer advertising non-existent jobs on behalf of a trademark owner. Sometimes there's actually a website that they create to go along with it that may look like the trademark owner's website, or at the very least, they're sending out emails, and requesting copies of, your passport or an application fee or a credit card number or, something else, which is obviously all just a scam. Obviously, if the domain name that is being used in that email, contains the trademark or is confusingly similar to the trademark, then, the UDRP is a viable option. And there are lots of cases with the facts that I was just talking about. But sometimes, the domain name does not contain the trademark or is not confusingly similar to the trademark. So there may be a website with content on it. Or perhaps, and I see a lot of these, email addresses, that will use a Gmail address, for example, and include the trademark, before the @ as the username. So it's not actually in the domain name. And in those cases, the UDRP, just does not apply. It's not a domain name dispute. So you need to look to some other type of potential remedy, like, perhaps a copyright claim, or, sometimes you can actually get the registrar's cooperation, depending upon who the registrar is and how egregious the violation is.
I've seen those cases as well. Sometimes I consider those to be pretty much of an emergency. I mean, people are getting scammed and giving away personal information and potentially sending in checks to somebody who's going to abscond with them. And in those kinds of matters, a 2-month time frame for a UDRP, even though that's fast, may not be fast enough. So if a URS is available for the domain at issue, that can be faster. That might be an option. Also, just writing to the registrar and letting them know that they're hosting a domain that's being used to defraud people. Sometimes they will stop it because it's in violation of their own policies, at least temporarily until it can be sorted out. And, you know, if all else fails, you can go to court and seek a TRO.
Great. And I have one more question from the group, and that is, you know, what do you do when the domain is not subject to the UDRP? What do you recommend? And just to add a little bit to that, maybe with particular attention to a domain that might also not be subject to the ACPA's in rem jurisdiction, because, you know, maybe the registry or the registrar are not located in the United States, so potentially a foreign country code domain. Do you go after those in any particular way, or use the country-specific domain name proceedings?
I think the gatekeeper question is whether whatever the bad thing is in the domain name or on the web page, and that's the most fundamental issue. And, you know, to have a remedy under the ACPA or the UDRP, you're going to have to find some bad act or some trademark issue in the domain name in particular. If the badness is in the page, then I think you're in regular court. I mean, there are plenty of many different kinds of remedies that are available. Certainly, the Lanham Act in general, the Copyright Act, but fraud, you may be going to, let's say there is an intellectual property, it's not a brand issue at all. You may be going to, it's one of the reasons that that we talked about the DOJ case, which is that fraud in general can be treated as wire fraud. The Microsoft case that I put in the TRO I put in the brief also has some creative remedies involving trespass to chattel and conversion. So I think the short answer is, if you're outside abuse in the domain name itself, you just have to roll up your sleeves and use your regular lawyer skills.
And I would just add, if it is in the domain name, but it's not subject to the UDRP, you know, there are these CC/TLD policies that exist. Some of them are actually more lenient than the UDRP. The .au policy for Australia does actually have that language that refers to bad faith registration or use. So in that way, it's more flexible for trademark owners. Some of them, you know, have other requirements. The .cn policy for China typically requires complaints and proceedings in Chinese. So if you don't speak Chinese or don't have access to somebody who does, then obviously that's a hurdle. Other policies, you know, are entirely different from the UDRP, but there are a lot out there. Some countries simply don't have a dispute policy whatsoever, and those are really kind of some of the more challenging places to deal with these issues.
Well, great. Thank you to our panelists and for staying so long and answering all these questions. Really a terrific program. Thanks to everyone who attended. We've been getting great attendance at these Zoom virtual events. And as much as we'd like to be together, we really appreciate everyone's continued support of the section. Lane Sosby at the bar, thank you so much for your help in getting this all set up, both technical and otherwise. Couldn't do without you. So, and Uma, thank you so much for your help as well, and helping me with this committee and putting on this presentation. So stay tuned for more from the Trademark Committee of the section. And I think our panelists have offered to share their slides. And if you need any help getting in touch with them, feel free to give me a shout. We'll make sure you get that. Thanks, everyone.
Ladies
Thank
and
you.
gentlemen,
Jason.
that does conclude today's meeting. Thank you for joining and have a great afternoon.